Representative O'Neill, and good afternoon to everyone. I'm very pleased to have played a role in facilitating this comprehensive stakeholder working group legislator victim advocate agreement. In fact, it is so well supported that it is the #1 priority of the bipartisan bipartisan caucus that met Monday morning to identify priority legislation for the end of the legislative session. We believe that now is the time and opportunity to address these issues. Among those issues are, of course, the Supreme Court decision that needs to be remedied, and I believe appropriately within the legislative purview for that to happen. And also the predatory offender registration, which we working group couldn't reach a final conclusion on, but which set up a proposal for an ongoing working group to work on that particular issue. That's critical since the changes to those laws will result in more beds in the state prisons, which means more registrants in the system as well. There's never been a better time for this predatory offender reform review because it's costing taxpayers $1 million a year, and the benefits of the predatory offender registration system are completely unknown, as it has never been studied for efficacy. It's simply been added to over the past 30 years. The hard and painstaking work of putting together a package of protections, well balanced and carefully crafted and years in the making, has now been completed. The final step is Senate committee legislative action. We have the committee time and the wherewithal tonight and tomorrow, and it's important to take these important and significant steps to protect current and future sexual violence victims. Representative Moeller.
Thank you. And just one other aspect of the bill that I really wanted to highlight for a second is the creation of the new crime of sexual extortion. The bill makes it a crime to force a victim to engage in a sexual act in order to avoid a consequence like loss of housing or loss of employment. We believe that this type of behavior is criminal and predatory, and that victims deserve justice in these situations without delay. Before we take questions, I also want to thank the many survivors who continue to tell us their stories and how our laws have failed them. They do this knowing that any changes to our criminal laws will only impact future cases, not theirs. And they, like us, want to ensure justice moving forward. And with that, we are ready to take your questions.
If members of the press have questions, feel free to use the raise hand function or send me a chat. Our first question will come from Bill Werner at Minnesota News Network.
Yeah, thanks, DJ. I appreciate it. I think this question is probably for Senator Latz. I need to frame it carefully because I know no one would endorse actions of people who do sexual assaults. However, Senator, I would imagine that there are some constitutional questions about protection of the rights of the defendant as well in cases like this, that there are certain perhaps presumptions that change if the law changes. Can you talk about what measures you have taken to ensure that this meets constitutional muster? And I think I'm sure you know what I'm referring to, so please.
Well, Bill, thank you for the question. And I know that we are all careful when we talk about these issues because they're sensitive issues. And I will highlight for you, I guess, the two areas where I was most involved in reviewing the particular proposals of the working group that caught my attention and that I know had caused some attention from the public defenders and from the Minnesota Association of Criminal Defense Lawyers. One of them had to do with the creation of the new felony in the 5th degree statute, which would separate and elevate the crime of sexual penetration from the somewhat broader category of sexual contact. The creation of the new felony raised two questions for us. One, where would a sentencing fall on the sentencing guidelines presumptions? And our review with counsel indicated that it would be likely set as a presumptive stay. And let me highlight, this is a first time, so no prior criminal sexual conduct convictions, to be a first time offender, and it would be non-consensual penetration, but not with any of the other aggravating factors that create the higher level offenses found in statute, first, second, third, and fourth degree offenses, like coercion, use of force, the victim is mentally incapacitated, for example, use of a dangerous weapon, positions of authority. Those are all separate aggravating factors that are all felony level offenses if charged and convicted. But this would create a new felony in the fifth degree statute. So the first question was, where would it be in the sentencing guidelines in terms of presumptive sentencing? And the second question was going to be, or was, would a conviction result in registration as a predatory offender, like it automatically does for the first through fourth degree convictions? And under the current predatory offender registration statute, it would create, it would be a mandatory registration. And as the group here has all agreed to, that will not be the case in the proposed legislation. So that for a first-time offender only, where the offense is the fifth degree non-consensual sexual penetration, that would not require predatory offender registration. The second thing that we looked at had to do with the availability of the intoxication defense in light of the changes that are being proposed here to deal with the mental incapacity element of the first through fourth degree offenses. That is the subject of the Supreme Court decision, which put the ball back in the legislature's ballpark. And the way that we address this is you would have a complainant who, by the nature of the element being charged, would have been so drunk, for example, as to be incapacitated and not in a position to make a decision about consent. But you could have an alleged actor who was said to have perpetrated the non-consensual contact or penetration, who could also be very drunk. And the question had to do with whether or not the intoxication defense would be available under those circumstances, because there is a knowledge component to the element of the offense. So the way the current law is set up, a defendant would have to be proven to know or have reason to know that the victim was incapacitated by, for example, consumption of alcohol or drugs. The question then would be, was the actor also so incapacitated by alcohol or drugs that he could not understand that what he was doing was overcoming or dealing with an incompetent or mentally incapacitated partner? So that's the other piece that we worked on, was to clarify in the statute that the intoxication defense would be available to a perpetrator under those narrow set of circumstances. So those are where we addressed what could have well been constitutional issues, certainly were statutory issues. We did not highlight any other constitutional issues that I identified. And I know that the public defenders and the MACDL, the Minnesota Association of Criminal Defense Lawyers, are accepting these adjustments to the recommendations. Also to promote, if not constitutional resolution, at least a more balanced and fair approach in the system to both those who are victimized and also those who are accused.
Senator and DJ, there may be other people with questions. May I do a follow-up? Otherwise, I'll
Go ahead.
Okay, thank you. I appreciate that, Senator, and I will frame this question very carefully as well. There is a presumption then, I would assume, and correct me if I'm using the wrong legal terms here, there's a presumption, I assume, that the perpetrator is, or that there is not consent, I should say, by the victim in these cases. is there a constitutional issue there as well in regards to protection of the defendant's rights in this case, in cases like this?
Well, Bill, as I understand the law in this area, and this is not a specific area in which I have much practice experience as a criminal defense lawyer, but I have learned a lot as I've gone through the details of this bill and the working group activities. It could touch on constitutional issues. The case law in the area of the availability of the intoxication defense, for example, doesn't seem to touch on the Constitution as much as it did on the statute for the intoxication defense under Minnesota statute section 609.075, which does specifically apply it only to specific intent crimes. Specific intent crimes are crimes where the mens rea or the actor in his or her mind needed to have intended the harm that resulted, not just intended the act which caused the harm. The easy way to understand that is if you intend to swing your arm, that's intending the act. If you intend to cause someone else to be afraid that you would hurt them by swinging your arm, that's intending the result. And that would be a specific intent crime where you intend the result. And the courts, I would assume prior to 1963, when there was a major recodification of criminal statutes in Minnesota, and certainly since that time when the intoxication defense was enacted, the courts have applied that intoxication defense only to specific intent crimes. And that's the way the statute is written as well. There was some ambiguity as to whether or not the knows or has reason to know language in the mental incapacity statute definition constituted a specific intent provision and therefore became available for the application of this defense. I don't know the common law before 1963. I suspect there would certainly be some constitutional implications if a person were charged with a crime that included their requirement to have a specific intent to cause a harm, yet they couldn't form that intent because they were too drunk to do so. I suspect that would have had constitutional dimensions as well. I haven't done that legal research.
Okay, so if I'm understanding you correctly, Senator, there may be some questions in this area that I brought up the inquiry in. Is that I want to represent what you're saying accurately, and I apologize to everyone for taking so much time on it, but this is a critical question, constitutionality.
Well, Bill, there may be some questions about it, but I think the statute addresses it, and I'm confident, based on what I know, that the way we have dealt with this in the statute would pass constitutional muster.
Thank you, sir.
Next question comes from Caroline Cummings at Channel 4. Go ahead with your question.
Hi, yeah, so I just want a little bit of clarification here. It would seem that this group here is calling for the passage of House File 707 and its companion in the Senate, which as you guys touched on, it deals with not only the mentally incapacitated language and updating it to reflect victims who voluntarily get intoxicated, but also the coercion piece that you described. But I'm trying to understand if the fate of the proposal as a whole, when it would seem that in the Senate, Senator Limmer is having a hearing tonight on an amendment to a big omnibus bill in the Judiciary Committee that just focuses on the mentally incapacitated language. So I'm wondering if you can, clarify like the potential fate of the bill as a whole, or is the most important aspect that mentally incapacitated language provision, which is obviously a direct response to the Supreme Court decision involving that sexual assault case.
Thank you for that question. And that's an extremely important question. And we are incredibly grateful that the Senate tonight is hearing the mental incapacitation language, but we are hopeful that they will consider the entire bill because, as you mentioned, it contains many important provisions that we've talked about, particularly protections for children, the sexual extortion, the 5th-degree felony. And so we are hopeful. It has really a great bipartisan support in both the House and in the Senate. And in fact, our bill filled up in the House with the number of authors, as it did in the Senate as well. So we remain hopeful, and I haven't talked to anybody, and I don't think my colleagues on this call have, who said they're opposed to the bill as a whole, or even any pieces of it. So again, we remain very hopeful that this entire bill can make it through to the end of session.
I will add, since the question did raise our hearing tonight specifically, and as I think, I'm the Democratic lead on the Judiciary Committee. It is our intent to ask Chairman Limmer to consider the entire package proposal tonight in committee and tomorrow during our final action on the public safety and judiciary budget. So we are putting the final touches on an amendment which will be released as well, and incorporates the changes that we have talked about today. And like Representative Moeller and Representative O'Neill, it's our understanding that Senator Limmer supports the overall package, and we're hopeful that he will give us the opportunity to add it to the committee action tonight and tomorrow.